Excellent. So good afternoon, good morning to everyone in the audience. I'm very pleased to welcome everyone here. My name is Andrea Chmielinski Bigazzi. I am the coordinator of privacy rules, and I also thank Alessandro Di Mattia here with us, although not visible, that supports also on the technical side. The webinar of today is particularly important. It's particularly important for three main reasons. First, as everyone knows, the new Chinese privacy law has created a kind of a turmoil in the privacy landscape. It's introducing profound changes and therefore compliance from companies from all over the world, not only Chinese companies, but companies from all over the world is critical. As a result of the new law, which entered into force exactly 24 days ago, we learned that some multinational companies from around the world have suspended their operations in China in the weight of complying, and therefore receiving advice from our experts is particularly important in order to know what to do next and adjust and therefore resume operations in China in a compliant way. And we are analyzing and discussing these new Chinese privacy law together with our Italian experts, representing in any case, if you want, all the legal experts from the European Union, because we will look at this new Chinese legislation with the perspective and with the magnifying lens, if you want, or comparative terms of the European Union General Data Protection Regulation. Before leaving the floor and having the pleasure of introducing everyone, let me mention the Privacy Rules is pleased to organize these webinars as other webinars, because we are an alliance of global experts, not only in legal matters concerning privacy and data protection, but also cybersecurity experts, represented in this case by Sharon. And we are now expanding also to communication companies that have a specialized expertise in cyber crisis communication. The reason being that all your clients, all clients out there, when they need important advice on privacy and cybersecurity, they need to count on not only legal experts, but also cybersecurity and communication experts. So Privacy Rules is nowadays the only alliance being capable of doing this in a holistic manner, in an integrated manner. All our experts are visible on our platforms, and also we can coordinate them. So Privacy Rules managing team can support companies and institutions in order to have a unified response and a unified managing of privacy matters. We are launching an entirely new website in a matter of days. So I ask kindly everyone in the audience also to visit us in the upcoming weeks, where you will see the new face of Privacy Rules. And I also take the chance to announce that 7, 8, and 9 of December, we will have a 3-day webinar around the world on privacy and cybersecurity in M&A transactions, the first day. In the gaming industry, very, very delicate, the second day, and the last day on international data transfers. I'll stop here because, as I said, it's very important to have this webinar today because of the new Chinese law, because of the quality of our experts, and also definitely because of the many multinational companies that registered for this webinar, who we definitely warmly invite to contact our experts. So east to west, we have Jihong Chen, equity partner at Zhong Lun being the 4th largest Chinese law firm. And we also have, again in China, Sharon Luo, who is the managing director of the Wizlynx group in China. It's a multinational cybersecurity company having offices also in China. And then in Italy, we have Chiara Agostini and Luca Egitto from RP Legal and Tax, one of the leading Italian law firms with offices in 7 different cities in Italy. Jihong, we start from you. Of course, we are discussing about the new Chinese law, and you are definitely our key expert for legal advice in China. Can you introduce the new law and tell us what has changed? Thank you.
Okay, thank you, Andrew, and thank you, every Privacy Rules members for organizing such a webinar. And hello, everyone, and our audience, and from west to east. And actually, I think that 2021 is a big year of legislation in the field of data protection in China. And one landmark is that Chinese PIPL has been promulgated by National People's Congress and came into force on November 1st. And this PIPL is broadly regarded as a Chinese GDPR and will have significant impacts on entities having business commercial presence in China. Let me first share my screen. Andrew, let me confirm, you can see my screen? Okay. Yeah, here's about myself, and just as Andrew introduced, I'm a partner of Zhong Law Firm. My practice will focus on TMT and IP. I will give my presentation in 4 aspects and how we got to now and introducing the legal framework and nowadays. And secondly, we'll explain the PIPL in 10 minutes, give a nutshell regarding the PIPL, and then make a very simple comparison between PIPL and the EU GDPR. Finally, I would like to introduce top 5 FAQs raised by foreign companies. Some of them are, of course, our clients. Okay, to nowadays, we can see that the legal framework of the data protection in China is basically formed. And we always see that there's 3 pillars of cyberspace administration and data protection, namely the CSAL, and which is came to force as of June 1st, 2017. And second one is DSL, which came to force as of September 1st, 2021. Another one is PIPL. Of course, it is our focus of today's discussion, and effective as of November 1st, 2021. And the 3 pillars are relevant, but each one has its own focus. For example, for CSL, the CSL will mainly regulate the multi-level protection scheme and network critical device and dedicated product testing and certification, CII security protection and cybersecurity review, and cybersecurity monitoring, early warning, and information notification scheme. As to the DSL, and this law will define the applicable scope, of course, and all the data processing activity will be regulated by this law. And data security standardization system, data security testing and evaluation, certification, administration, a classified and graded data protection scheme, and important data catalog, data security early warning and incident response scheme, data security review, and data transaction and online data processing activity, cross-border data transfer supervision. These are the main content of DSL. As to PIPL, and of course, and they mainly supervise and regulate the PII, mainly will prescribe the definition of PII and to decide the scope of PII, and provides a basic principle for PI processing and provides the rights of PI subject, rules on data localization and cross-border data transfer, PI processors obligation. Here is a whole picture and 3 pillars of Chinese cyberspace administration. And let's explain the PIPL in a nutshell. And first, I want to use that the PIPL has extraterritorial effect, and in some circumstance, for example, if the data processor is a foreign entity, but it will process the Chinese, the persons within China, they may be applied to this PIPL. First, for the purpose of providing products or service to the person within China, or analyze and assess the products conduct of a neutral person within China, or if any other situation provided by Chinese law or administrative regulation. And these three scenarios, and the PIPL still have the extraterritorial effect, and the foreign data processor still abide by the PIPL. And this law also prescribe the 7 legal bases for the PI processing. Besides the consent, the law also provides the necessity for a contractor, and also the employee and human resource management, legal duties or legal obligation for the purpose and of a public health emergency, or to protect the natural person's life, health, and public safety. News report and for processing of information has been made publicly by the data subject or through the lawful means. And here's the 7 legal bases for PI processing in China. The law also stipulates the individual's right, knowing and deciding, restricting and refusing, accessing or copying, obtaining and refusing, correcting and deleting. The 9 principle for PI processing: lawfulness, legality, necessity, sincerity, purpose limitation, data minimization, transparency, accuracy, and accountability. Outbound PI transfer regime and localization requirements will explain how we can conduct a cross-border transfer later. Many enterprises concern GDPR seriously because GDPR provides a severe penalty or liability. But compared with GDPR, I think that PIPL provides maybe several liability. Here's about the processor's obligation, and there's 3 layers obligation: staffing and system and security measures. And for example, for the PI processor in China, if the PI number reaches the threshold defined by CEC, and the processor need to upon our DPO. And for the overseas processor, if the overseas processor be applied to the PIPL, the overseas processor need to appoint a local representative in China. For the system, and the processor need to take security measures to protect the personal information, including the deploying the internal data policy, emergency plan, and procedure, adopting technical measures, such as encryption or the de-identification, establishing internal classification rules on personal information, and providing regular training. To conduct regular compliance review and audit system, to conduct the data protection impact assessment, etc. Here is a systematic obligation for PI processor. Regarding the administrative penalty, just I mentioned that the PIPL even provides several penalties, and besides the be ordered to make a correction, giving warning, and confiscation, and the regulatory bodies may also be order the processor to suspend or terminate its service, take down the APPs from sale, and also the fine. And the highest fine could be up to 50 million RMB yuan, or 5% of last year's annual revenue. Compared with GDPR, they are at the same level. And the person responsible for the processing of PI may have a personal liability. Any person in charge or any other individuals directly liable for the violation may be fined between 100,000 or 1 million. And there's a banning system. These people could be banned for a certain period of time from serving as a director, supervisor, or senior officer, or DPO. For the violation, PIPL may have a risk of a classified action. And actually, the PIPL introduced a system of classification and also a credit record. Let's compare with between the China PIPL and EU GDPR. And here's first, there's a few difference among the key definitions. And PIPL, we call it as personal information. And this definition is roughly equal to the personal data and the GDPR. And the PIPL, we use the term of processor, but this processor does not does not have the meaning of processor and GDPR. Here, the PIPL processor is roughly equal to the meaning of controller and GDPR. So if there's a cross-border data processing agreement between a European entity and a China entity, we must be forced to unify the term and to use the processor and the GDPR, or use the controller and the GDPR. We use sensitive personal information and PIPL, but this scope and meaning of the sensitive personal information does not equal to the special category of personal data. Here's a difference between the key definitions. Regarding the new legal basis, we have the necessity for contract and human resource management, but we know that under GDPR, there's no such a base of human resource management. We also have a base of processing or personal information that has been made public by the subject or through other lawful means. This new in PIPL. Another significant difference between PIPL and GDPR is the base of the legitimate interest. We must be aware that legitimate interest is not one of the legal bases under the PIPL. Some companies are processing PI relying on the legitimate interest. If they enter into China and must to seek to other bases for the processing, because we have no legitimate interest base. For the cross-border data transfer, and yeah, it is similar. We have the certification mechanism, and for the cross-border data transfer, the data sending party may obtain personal information protection certification pass. This is the first approach, and pass the CEC assessment and into our agreement, and it is a standard agreement provided by the SCC, provided by CEC, and this mechanism is quite similar with SCCS and GDPR. We have no BCR, binding corporate rules are not one of the mechanism and the PIPL. In some circumstances, CEC assessment is mandatory. For example, if the sending party is CIO, or the data to be transferred involves important data, And the two scenarios, and this will trigger the requirement of CEC secure assessment. But if you're not a CIO, but the quantity of personal information reach the threshold defined by CEC, and this scenario may also requires a CEC assessment. For example, PI processed by the single party is more than 1 million, or PI transferred overseas is more than 100,000, or the sensitive PI transferred overseas is more than 10,000. And these scenarios and CEC security assessment are required. Let's go to the top 5 questions raised by foreign companies. First one, does the Chinese PIPL apply to headquarters or offices in foreign countries? Probably, because we think that PIPL has extraterritorial effect, where the purpose is to providing domestic nature person with products or service, and or the activity of domestic nature person are analyzed or evaluated. And this scenario that the PIPL so apply to the processing activity of the foreign countries. The second question is, when is separate consent required, and what constitute our separate consent? Because that the requirements of separate consent in and PIPL is quite unique. There's no such a requirement and laws of our jurisdiction, and it is unique of Chinese legislation. According to the PIPL, and any of the following circumstances are separate consent so be obtained. PI processor provides another PI processor with PI from processor to processor. B, make public. And C, for the individual's imaging and personal information collected by the video or audio and the public areas, but will be used to the purpose other than public security, and that scenarios are separate consent is required. Processing of sensitive PI and or provided the PI of individual to oversee recipient is a cross-border data transfer, and these 5 scenarios a separate consent is required. What is a separate consent? And there's no very special or clear guidelines from the government, but according to our understanding, basically must be to ensure that individuals are allowed to give consent to the processing activity respectively. One person activity, one consent, rather than consent to a bundle of person activity. A bundled consent is not a separate consent. Question 3, when are we required to conduct PIA? Yeah, PIA is a compulsory obligation and PIPL for some processing activities. And any of the following circumstances, a PI processor should conduct a PIA beforehand and keep our record for all the processing. First, processing sensitive personal information to use automatic decision making, or entrusting other parties to process personal information, providing other processor with personal information of or publicized PI, cross-border data transfer, and all other personal information processing activity that have a significant impact on personal right interest. So, and these 5 scenarios, PIA is mandatory. The fourth question, what should the PIA include and how to conduct PIA? The PIA should include the following content and list. whether the purpose and the method or the scope of processing are lawful, legitimate, and necessary, impact on the personal right and interest and security security risk, and whether the protection measures are sufficient to prevent the risk. Procedures of PIA usually include the data mapping first, identification of the risk source, and third, personal right and interest impact analysis. Finally, synthetic assessment and risk management. Question 5, do we have a localized storage obligation for the personal information? Some conditions, local storage is required. First, if you are CIO and during the operation in China for PI or if important data collected during business operation, you must store the PI and import it within China. If not, you are not a CO, but the quantity of personal information reaches threshold, local storage obligation is triggered. And generally speaking, according to the mainstream understanding, and the threshold is roughly about 1 million people. Besides the general requirements and for some special data categories, and the local storage will be required by sector specific limited regulation. For example, the financial personal information or health and medical personal information should be stored within China. Andrew, that's all my presentation.
Jihong, thank you very much. Very clear, very comprehensive. And I was very pleased to see a lot of different items. The comparison from your perspective with the GDPR, and now we will move to the other side, so to the analysis of Chiara, but also frequent reference to the importance of security assessments, which is definitely what brings the added value of having Sharon here with us. In order to understand actually what's the role of the cybersecurity companies. I took so many notes, but actually there is no time. I'm conscious of time, so I will not go to my comments. I will immediately leave the floor to Chiara Agostini and Luca Egitto for their exposure. But of course, there will be room for some debate at the very end. And in fact, I take also the chance to invite everyone in the audience to use the Q&A button at the bottom of the page to start immediately sending us questions for our panelists that we will go through at the end of the presentations. And I also want to reassure everyone that this webinar is recorded and will be published on our platforms in the future, exactly because there is such a wealth of knowledge here that we don't want anyone to miss the opportunity to learn from our experts, leaving aside the possibility to contact them afterwards. Without further ado, the Italian and European perspective. Chiara, please, and welcome again.
Thank you, Andrea, and good morning, everybody, or good evening. It depends on where you live and where you are. I am Chiara Agostini, and I am one of the TMT and data protection partner of the independent law firm RP Legal and Tax, together with Luca Egitto that will talk just after me. And today we are here to talk about the similarities between the GDPR, which is the General Data Privacy Regulation in the European Union, and the new Chinese privacy law, the PIPL. We try to make a comparison to let understand you that the GDPR mindset has a very positive impact when accessing the new Chinese privacy law. Even there are a lot of difference, of course. I try to share my my screen. I hope that everybody can see. my my screen?
Yes, it's visible. Thank you.
Okay, fantastic. And this is my first slide, in which I highlight to you that there are several common features between the GDPR, as well as several differences. The first item I want to talk about is the scope of application, because these two laws are really similar concerning to their extraterritorial application. As you can see in this slide, particularly the first criteria that is used under the GDPR and under the PIPL is the territorial scope. It means that the laws in analysis apply when the processing of personal data is carried out by a data controller that is the office in the European Union or in the Republic of China in case of the PIPL. The other criteria for the scope of application is the profiling criteria, which is very important, because on the basis of this criteria, these two laws apply not only for companies that has an office in the relevant territory, but also when a foreign company, when a company that is outside the borders offers goods and services to people that live in the European Union or as well in the Republic of China, or simply monitor as a social media the behavior of such people. As you can see here, there are very little difference, but we can say that this concerning to this criteria, there is a substantial overlapping between the two laws. Another argument I want to talk about regards the subject to be appointed under the GDPR and the PIPL. Here, there is a slide on the representative that needs to be designated by a foreign data controller when a data controller carries out data processing that enter into the scope of application of the law in question. As you can see here, both according to the GDPR as well as according to the PIPL, a data controller needs to designate a representative in the European Union or in the Republic of China. And this representative, in the case of the Republic of China, can be a special agency or a representative, so a physical person. There is it seems to be a difference regarding the exception, because under the European law, when the processing is occasional and no special categories are involved, it is not necessary to designate a representative in the European Union. While under the PIPL, this exception seems not to be applicable. The second subject I want to talk about is the data protection officer, or using the specific words of the new Chinese privacy law, the person in charge of the personal information protection. This person is substantially has the same role and the same relevance in the at the data controller, but there are some differences that highlight to you here. Particularly, as you can see under the GDPR, And according to the GDPR, there are a lot of requirements that are required to be designated as a data protection officer, like professional qualities and an independent role. While under the PIPL, no requirements seems to be asked for this role. There is a duty to disclose such the information contact of the data protection officer to the supervisory activity, and this is a fulfillment that is required both under the GDPR as well as under the PIPL. And the main difference I can, of course, say regarding this subject is that under our law, under the GDPR, no personal legal liability is foreseen, while under the PIPL, it is provided a specific personal legal liability with specific sanction against the data protection officer. The last argument I want to talk about before introducing Luca are the legal basis. Here you can find the list of the legal basis that are relevant both under the GDPR as well as under the PIPL. I have to underline to you that here you can find the legal basis to process common personal data under the GDPR, while under the PIPL, these are the legal basis that seems to apply for any type of data. So also special categories of data, or to give you just an example, health data or political opinion, the political opinion of the data subject. Particularly a data controller under the PIPL and under the GDPR can process data on the basis of the consent for the conclusion of the performance of contract when it is necessary to perform statutory duties or obligation, for when it is necessary to respond to public health emergency, when there is a public interest. 5. The last 2 points are the difference that actually present the comparison between these two laws, because under the GDPR it is possible carrying out data processing on the basis of the legitimate interest of the data controller, and this legal basis is not foreseen under the new Chinese privacy law. And another difference is that under the new Chinese privacy law, it is possible to process personal data legally disclosed by the individuals, while under the GDPR, this legal basis is provided only for in case special categories of data are processed. Thank you for your attention. And now I introduce Luca for the ending of our Italian presentation.
Thank you, Chiara, and welcome, Luca. Luca, you might be muted.
Okay, thank you.
Voilà, perfect. Welcome.
Okay, thanks. So thank you, Chiara. So thanks for the people attending. I'm going to share my screen. Hopefully, it's going to work shortly. Can you see that?
Perfect. Yes.
Okay. So I'm focusing now on data transfer. Data transfer is a common feature between the two legal frameworks, although it has some differences. Has a common feature, we can say that both GDPR and PIPL basically do not allow export outside the perimeter of their scope of the application of these legal instruments. However, the consequences of these provisions are somehow different, as PIPL provides for a more robust intervention by the authorities, whereas GDPR has an accountability principle that, in theory, grants processors and controllers a higher degree of discretion as long as they can comply with this accountability principle. The assumption underlying this prohibition under GDPR is that GDPR provides one of the highest standards regarding data protection, whereas third countries do not meet as such degree of protection unless certain conditions are met. So there is a general restriction to export under GDPR unless conditions that are relegated between 44 and 49 GDPR are met. However, there are a number of similarities, but as I said, under PIPL, the intervention of public bodies is more robust. For example, we have heard before that in case certain thresholds regarding the quality and quantity of data processing are met, then there must be a security assessment by a state cyberspace administration, which doesn't exist under GDPR. So under GDPR, what we have is an individual assessment and decision by the controller or processor willing to export. This is a decision which can be free of any scrutiny unless critical aspects come up. So there is no prior review by a public body. Also under PIPL, we've learned that there is a certification path to be pursued under supervision of a specialized agency. There will be, as far as we understand, standard contractual clauses, which is a similarity with GDPR, and also the possibility for China to enter into frameworks or agreements with other parties regarding the transfer of personal data, which is another similarity with GDPR. We've seen that GDPR provided for certain arrangements that somehow were repealed or otherwise blown away by the ECJ. The GDPR provides for adequacy decisions, which are unilateral decisions by the European Commissions that, however, arise and come after discussions and arrangement between the European Commission and the concerned third party. Again, another similarity is this general provision that allows transfer to be pursued when there is a legal instrument allowing the processor or controller to do so. What is a requirement for controllers in the event an export to a third country occurs is that obviously the data subjects need to be aware of this transfer. So this is a very common feature between the two jurisdictions, or I would say the two legal instruments. Under GDPR, almost the entirety of transfers is governed by an agreement. So it's an arrangement between the two controllers or between a controller and a processor in a third country. Again, this applies also under PIPL. So it's a common feature, and it's, I would say, a very natural consequence of the fact that there are two ends of the transfer that need to arrange on sufficient safeguards to allow this transfer to be consistent and complying with the underlying data protection legislation. Under PIPL, there is a requirement for consent, which is just one of the scenarios under 44-49 GDPR section of the European legislation. Under GDPR, there is no general requirement to carry out a data protection impact assessment. However, after the ECJ scrapped the privacy shield, the EDPB issued warnings and recommendations that basically imply that exporters need to carry out a transfer impact assessment when the recipient third country appears to provide lower standards of protection, and this obviously applies to the US. So in general terms, there is no requirement to carry out a DPIA to transfer to third countries. However, when third countries have specific risks for freedoms and liberties of in data subjects, then we need to carry out a transfer impact assessment. So it's an impact assessment specifically focused on the dangers and risks of the transfer itself. Whereas we see in PIPL that there is a requirement for a PI personal impact assessment. And also there are requirements on where data may be localized, which is something that doesn't occur under GDPR. Another difference in the approach relies on security measures. So that are the measures that need to be applied and implemented in order to secure the processing and to make sure that processing is carried out in compliance with the underlying legislation. So GDPR relies on the accountability principle, which means that processors and controllers are kind of free to decide what is the best option as regards security measures. They can, every controller need to be aware of the risks, need to detect all the potential risks, and then adopt the measures that, according to his assessment, are sufficient and enough to protect personal data. Whereas in PIPL, we've seen that security measures are provided by the law. In Italy, we used to have something similar. So previous legislations back in the days had an indication of security measures that could be used, but now this has been repealed. So as I said, in GDPR, every controller and processor is free to adopt the measures he considers appropriate as long as they are sufficient to protect personal data, whereas under PIPL, there is a legal framework or a legal threshold for security measures. Obviously, this is a conclusion we came to by reading the presentations, the law, and listening to the Chinese advisors. But again, this is something that requires a more focused approach assisted by a Chinese specialist on data protection and cybersecurity. But I think it is worth highlighting the difference in the approach, which does not necessarily mean that under GDPR things are easier, because this self-assessment is nowhere near being easy or very viable for most businesses, but it's a radical difference which deserves to be highlighted. So what is the takeaway from this? So on the one hand, obviously businesses, especially European businesses that are concerned with data processing in China, obviously need to take into account PIPL, need to adapt it to comply with PIPL and to understand the impact of this legislation. A painful suggestion, but unavoidable, is that you need to allocate budget to comply. Compliance has a cost, but is an investment. So it's something that allows businesses to move in new scenarios with somehow some decent protection. Obviously, there's also a clear advice from our end to monitor the application and implementation of PIPL. We've seen that there will be novelties, and also the colleagues that spoke before me anticipated that there are further novelties to be introduced. So this has to be obviously monitored very carefully, considering the importance of this jurisdiction. But again, what we can say, maybe in a quite optimistic manner, is that if you have a GDPR mindset, then you have an advantage, and you need to bank and rely on the GDPR experience, because a compliance and governance system within the business adopted for GDPR would definitely be of help in complying with PIPL. So I'm done with the presentation. I thank you so much for taking your time to listen to me and to Chiara and all the people that spoke before me. And now I pass it on to Andrea. Thanks.
Thank you very much, Chiara. Thank you very much, Luca. Absolutely clear, wonderful comparison in between the two legal frameworks. I just cannot agree more with what Luca just said, in particular regarding the fact that compliance is an investment. Jihong already showed us before that sanctions against violations of privacy regulations are getting GDPR aligned, in the sense that they are now getting to 5% of annual turnover. I remind everyone in the audience that for the moment, data protection authorities in Europe have been quite lenient, and they were more towards the maximum amount identified in 20 million euros rather than in the annual turnover. But once we get there, these investments in compliance will become really one of the must policies for any business strategist. Also, definitely, Chiara and Luca underlined the need for cybersecurity expertise, which is required by the PIPL. It couldn't be a better introduction to Sharon. So Sharon, now definitely the word is yours, but that's definitely the attention is on you, because you are in China. You are a cybersecurity specialist of a company also based in Europe. Therefore, nobody better than you that can shed light on these impact assessments and others required by the new legislation. Thank you, Sharon.
Sure, thank you. I will share my slides. Hi everyone, I'm Sharon. 大家好，罗小兰, the manager of Wizlynx Group China, and I'm located in Shanghai. I have been working with Wizlynx for more than 10 years. And today I'm really honored to be here, share the information related to personal information protection law from a cybersecurity perspective. And I guess many of you are interested in what specifically we should do as a personal information handler. So in the next few minutes, I will outline the main requirements within personal information protection law from our perspective, and I will break down the 4 steps needed to comply with the PIPL. Additionally, we will talk a little bit about the main components, and last but not least is how Wizlynx Group can help you with the compliance. Before doing so, I would like to introduce Wizlynx Group and our background to you. So Wizlynx Group is a cybersecurity service provider founded in 1992. Our headquarters is in Basel, Switzerland. Our branches covered 8 countries, and we have more than 100 cybersecurity experts and served more than 2,000 customers worldwide. We have analyzed the impacts and the requirements of personal information protection law in China and identified the 5 articles that impact cybersecurity, governance, risk management, as well as employee awareness, which we believe are critical to achieve the compliance. After our experts familiarize with the personal information protection law, we have developed a summary of the main cybersecurity compliance requirements, which we have outlined in the slides. So in the chapter 5 of the PIPL talks about the obligation of personal information handler, which actually refers to those companies who are doing business in and from China. So the Article 51 requires to have internal management system and operation rules. requires to have technical security measures, requires to have security education and training for employees, requires to have plan of emergency response to personal information security incidents. And Article 54 requires to have to perform regular compliance assessment against the PIPL. Requires 56. Article 56 requires to perform personal information protection impact assessment. And Article 57 requires to establish personal information breach notification. And Article 59 requires to have technical safeguards to ensure personal information. So moving on from the main cybersecurity requirements, we have identified the 4 areas of concerns and identified the actionable tasks for CISOs and data privacy officers. Starting on the top left, we recommend any company who that is affected by PIPL to perform PIPL risk and compliance assessment to meet the requirement of Article 54 and Article 56. This way will also help your organization understand where the gaps are and what immediate measures should be taken. Next, PIPL requires to establish information security management system, implementing policies, procedures, as well as rules within organization. And to satisfy some of the more technical safeguards, we recommend to start with performing penetration testing on your systems, applications, and database to identify any missing technical safeguards and trigger the remediation to meet the requirements of Article 57 and Article 59. Last, PIPL requires employee, often the weakest link, to be trained and regularly tested using social engineering techniques and training to meet the requirement of 59. So in summary, PIPL is actually nothing new for any CISO or data privacy officers. It simply enforces the best practice that's well known and used in the industry such as ISO 27001 or ISO 27002, NIST, GDPR, etc. So to satisfy with the PIPL assessment and risk management, as well as the information security management system, our consultants can guide clients using our partner's solution, 360 in control, to support with client with assets or data inventory and classification. As assets or data is the most information, is the most valuable information in your organization, right? We can perform risk assessment to identify and proactively manage risk at all levels. And finally, we can perform PIPL audits and compliance assessments to ensure all requirements have been met and be able to attest compliance to external parties. Phishing simulation and awareness training is actually probably the easiest and the most important task that all companies should fulfill. Well, based on the latest version of data breach investigation reports, phishing is still the top threat action in breaches. I think because the cost for a hacker is very cheap, and human is the weakest link in security chain. People may easily give up their credential information when they feel curiosity, helplessness, or urgency, etc. So using our phishing assessment and training platform, we can help our clients with realistic simulation and leverage phishing campaign to train to train end users and monitor the real-time campaign statistics via our dashboards. And we do create reports on an ongoing basis. Okay. So when trying to assess the maturity of your organization technical safeguards, the most effective way is to have offensive cybersecurity assessments to let an attacker show you if and how the technical safeguards can be circumvented. So Wizlynx Group is a globally approved threat penetration testing service provider. We put our faith into hackers' shoes and we leverage a global team of resources comprised of highly skilled security professionals and penetration testers with extensive experience that not only tests your system, but also provide you with detailed mitigation activities that to further improve your system and network security. Well, that's all for my sharing for my topic today. And I'd like to say thank you, 谢谢 for your attention, and encourage you to reach out to me or our team for any question or support. Thank you.
Sharon, share to you, I mean, really a clear manifestation of the spirit of privacy rules, I would say. Why in our alliance we have legal and cybersecurity experts. I mean, you have started from an analysis of the law as you were a lawyer, and then you have translated how in practice you as cybersecurity experts can provide assistance in compliance with the law. So I believe that this is extremely useful for everyone in the attendance. We have learned from Jihong, from Chiara, from Luca that the sanctions out there are very severe. The requirements are pretty strict, and also for what concerns the transfer security assessment. The penetration testing you were mentioning is one of the most important tools in order to identify whether companies before started transferring actually might be vulnerable per se, and therefore that's probably really the step one in order to see where to fix problems before and engaging in an activity that might even lead to personal liability, as Chiara and Jihong underlined, and not only company liability as it is under the GDPR perspective. Again, I want to reassure everyone that this webinar is going to be again available through our platforms, because definitely you have all provided fundamental information. You have all underlined also the need for training of workforce. Of course, there is need of training at different levels, different specifications on the basis of the roles of employees of companies, but it has become clear that everyone dealing with data in one way or another, consciously so or unconsciously so, are part of a chain, and therefore basic to advanced privacy and cybersecurity training has to be provided. Which, of course, I mean, this is one of the services that Privacy Rules is working on and providing. There were some questions, and for the benefit of those who actually see the recording of this webinar, I will go to read one question that was already answered by Jihong in the chat. The question was, do we need to notify the representative within the territory of China? Is it mandatory to be able to communicate in Chinese, or it is sufficient to communicate in English? And the answer from Jihong is yes. There must be a representative in China that is appointed, and the appointed representative will be the one to notify the CAC. So Jihong, I understand the notification has to be done in Chinese. Is that correct?
Yeah, because that the rule of the representative is communicated with the regulatory body. I think that is a basic skill is to use Chinese to communicate with the regulatory body. I think that language skill is a must.
Okay, excellent. And a question for you legal experts. I say you in the sense of both Jihong, but also Chiara and Luca for their perspective from Europe. The question is, the Chinese standard contractual clauses have not yet been drafted. So could you confirm that, on the basis of your experience and also on the basis of your best guess, so to say, in the absence of the SECs, can you confirm that currently the only way to transfer data outside the Chinese territory in compliance with the PIPL regulation is the approval of by the CAC?
Yeah, maybe I first give my comments. And according to PIPL, actually there's a few approaches for approaches to conduct the cross-border transfer. And besides the SEC, we also have the certification and also CAC assessment. We understand that CAC is now drafting the Chinese SECs, and we expect that SEC will publish the Chinese SEC soon, maybe at the end of this month or at the beginning of next month. So soon you will see the Chinese SEC.
Excellent. Jihong, thank you very much. And also I want to underline again, according to your presentation, which was very exhaustive, the assessment by the CAC is also a security assessment. So once again, it's not only an assessment of the legal requirements, but it's also an assessment from the side of the cybersecurity perspectives before engaging in the transfer of data. This is important to underline. Oftentimes, if you do that afterwards, you are already in violation of the requirements and therefore subject to potential sanctioning. Chiara and Luca, what would you advise a European company to do in this regard, therefore? So before engaging in the data transfer, can you simply concur with Jihong or would you want to elaborate more?
No, I have no reason to dissent, or because obviously he is more focused than us. In general, if it were under GDPR, if a certain conditions is not viable, then you need to rely on the existing one. And so I think that this is also consistent with Jihong just said. So yeah, but the advice would be to seek the advice of the Chinese advisor in this case.
Perfect, thank you. I would like to ask Sharon, please, to look at the questions submitted by Jihong Chen. I don't dare to summarize them as I'm not the cybersecurity expert. Probably they are clearer to you. So if you could prepare a response to Jihong Chen. But I take also the chance to mention here to another question submitted by Rafi Nabil that elaborating on the 9 principles and in particular the differences between legality and lawfulness might take quite a long time. We went already far beyond the allocated 1 hour for this webinar. So unless Jihong, you have any 1-minute answer on the difference between legality and lawfulness, I recommend Rafi to get in touch with Jihong later on and possibly satisfy questions related to the 9 principles in particular. And obviously, I took note of 2 adjectives that Jihong used during his presentation. To the question number 1, he was saying probably, and to the question number 4, he was saying is highly likely. Evidently, the new law has just entered into force. Like everything in privacy and cybersecurity, it's changing by the minute. So there is always the need to go to experts. Any answer you might receive today might change tomorrow because of a new guideline, a new regulation. Luca was mentioning the European Data Protection Board issuing recommendations that, although they are not technically law, they have a tremendous impact on the practice of every company the day after. So, especially for principles, it's very important to really consult a legal advisor and get clarification before any action from companies is taken. So I don't know, Jihong, if you want to elaborate between lawfulness and legality.
Yeah, I think that for to the nine principles and the difference between the lawfulness and legality is quite detailed, technical, and I think that we may communicate discuss such issues by email or by other means, and it is need a long discussion.
Yeah, indeed. Thank you very much. Sharon, are you confident with providing answers or indication to Mr. Chu?
Oh, I didn't see it.
It's in the Q&A string at the very beginning. In the meantime, I can go through another question. Another question is under the PIPL, if we are an overseas data processor providing service to global customers, including Chinese corporations, and some individuals of the corporations provide the personal data to the company in question, is this considered as a cross-border transfer of the processor, or is the individual corporation itself transferring a cross-border? That's a very interesting privacy philosophy question, I would say.
Yeah, Andrea, maybe I can try to answer the question. And if you're doing business of B2B business, that means that your partner in China is a corporate, and the corporate is a PI processor. And so the PI processor in China should comply with laws of China and conduct assessment or any contract of SEC with you. So a Chinese partner is a PI processor, and you are the overseas recipient.
Excellent, thank you.
And so, any scenarios, and it is should be understood that it is a Chinese corporate transfer the data cross-border to you, not to the individual.
Thank you very much for the specification, Jihong. There is another question to you. So before the issuance of the standard contractual clauses, the question is very direct. Shall we sign a data transfer agreement drafted by ourselves, or you are meaning, of course, shall a company sign a data transfer agreement drafted by itself, or shall it wait? So do you suggest to wait until the issuance of the SECs?
My personal view is the wise strategy is just wait, and because that we expect the China SECs will be published soon, and if we now in a contract rather than the SEC by SEC, and if the CEC publishes the SEC, we must to revise or change the contract, and the efficient way is just wait and wait for the SEC published by the CEC.
Perfect. Thank you very much. Sharon, I don't know if you have anything for Mr. Chu.
Yeah, I saw the question is was that you mentioned that was the new PIPL allows the use of technical such as 3DH or endpoint encryption. Is that question you mentioned?
Yes.
Oh, okay. So in the PIPL, it's required to have technical safeguards that should be ready to be in place, but it's not specifically mentioned what technical safeguards. So it as an enterprise, you still need to have security risk assessment, and to not only, but it may be a safe one of the technical safeguards, you know, to protect those data. Yeah, but it doesn't written in specifically what technical safeguards inside.
Excellent. Thank you very much. And once more, it's advised for technical additional guidance to contact Sharon in particular. There are no other questions. There were thanks in the Q&A for the answers you already provided, and really warm thank you for me to all of you. We said already in the very beginning, I mean, this law is revolutionary. The changes that continue happening in the data protection world are every day changing how companies have to operate. You know, we don't want to create terror, but we have to remind, it's a part of, you know, ethical duty to remind that the sanctions are out there. And so definitely, again, quoting Luca, investing in privacy and cybersecurity, spending in privacy and cybersecurity is an investment in the future. So this is definitely something that I'm sure everyone in the audience is sensible to. How to strategize these investments and how to allocate resources, definitely contact our experts. You can make with them a strategy on the basis of your resources, on the basis of your policies, on what you want to do next. And definitely, because they have hands-on experience on a daily basis on how also data protection authorities behave and think to some extent, you know, asking them what to put in the pipeline of company strategies is very important. So thank you very much, everyone. The publication of this webinar should be available on the 1st of December, if everything goes okay. In this, I thank again Privacy Rose team and Alessandro Di Mattia in particular. I believe until the next, because most probably international data transfers also on the basis of the questions we received, in light of the new regulation, might be something worth discussing in a new webinar soon. So probably we will see each other again not far from now. I don't know if there is any last round from any one of you. Otherwise, thank you very much again, and see you next.
Thank you.
Thank you.
Thank you.
Thank you.
Bye, everyone.
Goodbye, everybody.
Bye-bye. Bye.